Agency. I want to touch very briefly on the issue of agency. As you may recall, one of the fundamental principles of contract law is that only those who are party to a contract can sue or be sued under it. In an agency situation, a party does not deal directly with a supplier, but through a supplier's agent. However, the contract between the party and the supplier is direct. In law, the agent and supplier, known as the agent's principal, are the one and same legal person. As such, in the event of a problem, your right of action is against the principal, not against the agent. The agent has no obligations themselves under the contract. In most cases, the agent will be acting under the actual authority of the principal, doing what the principal requires in the way required. This may be express actual authority, for example, a documented agency agreement, or an implied actual authority through, say, a course of behaviour. However, it is possible that the agent acts outside the scope of his or her authority. And going back to the question of who can sue and be sued, if the agent does go outside the scope of their authority, is the principal responsible for the agent's actions? The general principle is that, under certain circumstances, an agent can indeed bind a principal, even where the agent acts outside the scope of their authority. See Freeman and Lockyer and Buckhurst Park Properties. For this to arise, 4 things are necessary. First, a representation by the company made to the contractor that the agent had authority to enter on their behalf into a contract of the kind sought to be enforced. Secondly, that the representation was made by a member of the company who had actual authority to manage the business to which the contract relates. Thirdly, the contractor was persuaded by such representation to enter into the contract and relied upon the representation. And fourthly, that under its memorandum or articles of association, the company was not deprived of the capacity either to enter into the contract of the kind sought to be enforced or to delegate authority to enter into that contract to the agent. However, whilst if those 4 principles are made, the principal may be liable for a contract that is created by virtue of an agent acting outside the scope of their authority, ostensible authority does not arise where the party alleging to have relied on the representation knows that the agent's authority is limited so as to exclude entering into transactions of the type in question. In that case, they cannot have relied on any contrary representation by the principal. See the Russo-Chinese Bank case. An agent who purports to act for a principal, but in fact has no authority to do so, may be liable to that principal for breach of the warranty of authority. This potentially puts the agent on the hook for the transaction into which they entered. See Collin and Wright. However, as this is a common law principle, the principal might want a clear contractual basis to take action against the agent, for example spelling out clearly in the agency agreement what happens if the agent acts outside the scope of authority.